right. Hey, everybody. Nice to be with you virtually today. Welcome to the HSB Employment Team's first webinar for calendar year 2023. We're going to be doing today sort of calling it a legislative preview, but it's really a sort of hot topics type of presentation on some things that HR might expect in 2023 on a legislative standpoint, as well as just updates and things like that. Hey, I see we had a large number sign up for the webinar today, which I'm excited about, and it looks like we've got a pretty big showing for participation as well. So, please pop into the chat and the Q&A and say hello and make any comments that you see fit as we go throughout. A couple of reminders for those of you who may be new to our webinars. Our employment team here at HSB runs a blog, scemployersblog.com. I encourage you to check that out. You can find out information about future webinars, future events, as well as just legal updates that'll come directly to your email if you subscribe. We are not, we don't blog too much, so it won't clog up your inboxes, but we do try to provide helpful legal information where we can. As I mentioned, we've got the Q&A and the chat box. Feel free to use those as we go today. I'm doing this one solo today, so it may be hard for me to monitor while I'm going through the presentation, but I'm definitely going to leave a little bit of time at the end to address any questions or comments. But I definitely like to see feedback from the group and comments from the group about some of the issues that you're facing. So please do that. We'll provide both the slides and a recording following the event for you. And just a legal disclaimer that I'm not providing any specific legal advice to you on any specific situations, just more general information to you today. So with that, we'll go ahead and get started. A few things we're going to talk about. We'll talk pretty high level about where we are in the economy right now and where we might be going in 2023, and then a number of legal hot topics for 23. It's not intended to be fully comprehensive. I've done my best to, make notes over the last few weeks of things that have really caught my eye, or, things that clients are asking me about. So if we don't talk about something that you see on the horizon, or, you and your department are thinking about, please feel free to chime in with that as well. So with that, we'll go ahead and get started. I usually like to start these these types of presentations with just sort of an update on where I see things in the economy. And I like to put my morning squawk box viewing to good work. And also just through working with clients, hear a lot about where the labor market is. As you're probably aware, the U.S. Federal Reserve has really been trying to get inflation under control. Inflation was sort of the big story in calendar year 2022. And so really the Federal Reserve is kind of in the U.S. the body that is tasked with sort of trying to control that. And really their best tool for doing that is raising interest rates. In an attempt to slow down inflation, what raising interest rates does is that it sort of cools off and really slows down the economy. I'm sure many of you have been, paid attention to what the stock market did in 2022 and had your eye on your 401k balance and things like that. But, this really does lead to sort of a decreased demand for goods and services. And, you hear people talking about the idea of a recession all the time. It's definitely a weird economy that we're in right now. I think, hiring has slowed down a little bit, and unemployment's creeped up some. But for the most part, despite the rising interest rates, the labor market has actually stayed pretty strong. Um, Compared to what a lot of experts have thought. Now, inflation and wage pressure is probably for most of you, on the wage pressure side, still probably a big short-term concern. I don't think the Federal Reserve's actions have sort of made their way down to a lot of small and medium-sized businesses. So you're still probably, in order to attract, and recruit good candidates, you're probably still really feeling the pinch of having to pay, premium to attract talent. But that's kind of where we are currently with the labor market. And you've probably seen in the news a lot of announcements starting in sort of the third or fourth quarter of 2022 about layoffs. There's been a lot of high profile, primarily technology companies, big technology companies, laying off a lot of their workers. That's been some in the financial sector as well, some of the big banks and things like that. For the most part, just anecdotally working with my clients, I have not seen that trickle down to a lot of medium-sized businesses in South Carolina. You all can, let me know in the chat if it's something that you've had to deal with recently. Hopefully it's not. I think that overall demand is still pretty strong for workers. But a few things to keep in mind. I have worked with several clients over the past year with respect to doing layoffs, and they can be a lot more complicated than just sort of a simple termination of somebody's employment. There are laws that are triggered when you do a layoff. Most companies that I work with that lay off employees offer their workers some kind of separation package. And if you're going to offer a separation package to workers in conjunction with a reduction in force or a layoff, there's certain laws you have to comply with. One is the Federal WARN Act. It's a law that applies to larger businesses. Businesses with at least 100 employees. And that law generally provides that employees are to be provided with a 60-day written notice of a layoff. There are all kinds of exceptions to that general rule. There's sort of formulas for determining whether or not your reduction in force actually qualifies and that type of thing. And anytime I have a client ask about this, I always have to sort of pull up the WARN Act and refresh myself with the facts of each case on how it works. But that's just something to keep in mind. And then the Older Workers Benefit Protection Act provides that if you're offering a separation package, there has to be certain time periods for the employees to consider that separation package, and certain disclosures in writing concerning the reduction in force and the ages of those that are going to be laid off. One of the tricky things from a legal perspective with layoffs is that they often lead to age discrimination claims. Older workers seem to be most adversely affected by layoffs, whether that's because of skill set or whether that's because of more experienced workers having higher wages. Whatever the case may be, it's sort of it's typical for me to get something from a client about layoffs and see a lot of older workers on there. So that's something to keep on your radar. You know, the best way to avoid liability on that is making sure that you're using valid, non-discriminatory business reasons for making the decision as to who to lay off. So switching over to, you know, politics and government and legislation and things like that. The 2022 midterms were a little bit of a surprise, I think, in that the Republicans did gain a narrow advantage in the U.S. House of Representatives, but Senate control and the presidency remained with the Democrats, of course. And so we have a divided government at the federal level for 2023, which means that, you know, as has sort of been standard for a while, it's sort of unlikely to see any new major employment legislation at the federal level. As most of you know, however, most significant employment regulation in this day and age comes through federal agencies like the Department of Labor. We'll talk about the Federal Trade Commission later. The EEOC, you know, those types of organizations, and there's definitely some things in 2023 that I think we're going to see from some of the federal agencies. So one of those federal agencies that probably most of you have more interaction with than any other is the Equal Employment Opportunity Commission. Democratic nominees now hold a 3-2 advantage as far as commissioners go, which typically means more aggressive action taken on behalf of the EEOC, more lawsuits filed against employers. A couple of Democratic priorities there. Pay equity is certainly one of those priorities that we see, and gender identity and sexual orientation discrimination is another one. And, you know, not going to really talk about those in today's presentation, but just something to keep in mind that those are EEOC priorities. One thing I did not include in today's presentation that some of you may be curious about is news on the traditional labor and union front. That has also been a significant priority for the Biden administration, and you know, it's been in the news a lot. Some of you have probably read, you know, in the State or the Post and Courier about Starbucks locations in South Carolina and some of the union activity and ongoings at those locations. It's a little bit, I know this for the most part, you know, it doesn't apply to a lot of you, but you know, it's a little bit hard the statistics that come out kind of vary on whether there's really an increase in union activity or not. It does seem like there's a very certain sector of the economy, the places like Starbucks, these, you know, small retail type operations that are seeing an increase. So that's something to keep in mind as well. Not really covering it in today's presentation, but I thought about it because it's another sort of priority of the Biden administration here. So with the midterm elections, a few things that happened. One is that 2 more states approved ballot measures to allow recreational marijuana use. I think we should have the most recent map here showing those states in green that have both medicinal and recreational marijuana use, and those states in yellow that have it only approved for medical purposes, and then a lot of states there, South Carolina, North Carolina, and Georgia sticking out for our purposes, who still don't have either a medical or recreational use law. Those of you on here who are clients of mine or been attending these for a while have heard me talk about this for years now, and keep predicting that it's going to happen in South Carolina. Certainly will one day. Not sure exactly when that's going to be. It's certainly going to be a topic on the General Assembly's agenda for this year. It year by year, it seems to pick up a little bit more steam, pick up a couple of more representatives who are supportive of it. The General Assembly has been very busy with a lot of non-employment related issues, and so I'm not sure what the chances are of it happening in 2023, but we'll have to keep an eye on that. North Carolina and South Carolina also have similar measures. They may beat us to the punch there, but we'll just have to wait and see. One thing I wanted to point out, and you can stay there on the slide, Brittany, that's fine. One thing to point out with this is, of course, that, even though South Carolina doesn't have a law in place yet, you may have workers that, in other states, you may have workers working remotely in other states that could be subject to one of these laws. So it's really a good thing to keep an eye on. I've got a bullet point there that says usage is growing, and employers have got to have a response for dealing with the issue. I have a lot of clients that ask about what to do with that and CBD. One big trend from an employment perspective that I see continuing in 2023 is businesses that have workers spread out, among many states. For some of you here today, that's always been the case. You may be working in an HR department in South Carolina that has, you're working for a company that has 7 or 8 locations spread out across the country, and you're sort of used to the fact that you've got to think about, what does Texas law say on this, or what does California law say on that? But getting more and more clients that, even if they only have a South Carolina presence, they are hiring workers in other states that work from home or work remotely. And so that's something to keep in mind with this. And COVID, of course, it sort of exacerbated that. Not that it's a particular problem. It's good in a lot of ways, but it certainly has made a lot of companies look outside of South Carolina to hire workers. And 2 of my colleagues, Chris Gant-Sorensen and Tyler Gillum, recently did a blog post on our blog. Got it printed out. You can see it here. You probably can't see that, but it's a compliance checklist for employers with out-of-state remote employees. This was posted on January 19th. Just here recently, and it's a really good read. If you hadn't gone through it yet, and you've got workers somewhere other than South Carolina, I would really encourage you to go through it. It's got everything like business registration, payroll tax, registering with the unemployment commission in that state, thinking about all the state specific employment laws and things like that. So I would encourage you to check that out. I think that's definitely going to be a trend that continues into 2023. I've got a couple of bullet points there about the pending legislation, the Compassionate Care Act in South Carolina. Won't spend a lot of time on it since it's not law yet, but it is just a medical law that, is pretty narrow medical use for serious medical conditions. And fortunately, there's a lot of employer protections built into that proposed legislation. I don't think South Carolina is going to pass a law, without some serious business protections as far as what businesses have to tolerate with respect to their workers. That bill does not provide any private right of action to sue an employer over it. And there's no requirement in that law to accommodate an employee's use on the premises or even be under the influence while at work. So drug testing and things like that would still be okay. Another thing from the midterms, 2 more states increased the minimum wage. With inflation and wage pressure, the sort of federal minimum wage has become less and less relevant at the federal level. And in South Carolina, it remains at $7.25 an hour. I guess theoretically speaking, it could become an issue again if we go into a recession and wages go down. But I rarely see clients with employees, at that level currently. So, I mean, the issues that I typically get with respect to wage payment these days are clients coming to me and, they've had to, they had a position in mind that was $50,000 a year, posted for $50,000. And, in order to hire somebody, they've had to go up to 60 for that position. And, they're wondering, okay, does that mean we have to raise all our other workers in that position up to that level? Is that going to lead to discrimination complaints if we've got pay disparity there? So I see a lot more of problems with sort of that come along with paying people too much in this current economy, which is, in some respects, a good problem to have from a worker's perspective. Pay transparency has been a trend that we've seen in many states. New York City passed the most recent high-profile pay transparency law. This is going to spread. I'd be surprised if anything gets done at the federal legislative level on this, but I do think it's going to spread into other states. And the idea with pay transparency laws is that there's this gender pay gap out there, and these laws are designed to address that and to try to fill that gap. And so basically, you've probably read some about the New York City law, but employers are required to advertise the salary range for jobs, and this applies to looking for external candidates, promotions. It's very broad reaching, and it applies to jobs that can or will be performed in whole or in part in New York City, whether from an office in the field or remotely from the employee's home. So they're trying to capture everybody. They're trying to capture people that live in New York, work in New York, whatever the case may be. And I've had a surprising number of clients that have had employees that this has come into play for. And what the law basically says is that you've got to post the minimum and maximum salary that you believe in good faith that the job would pay. And there's been a lot of businesses that have responded to this with essentially, posting huge ranges for positions to say, okay, well, if you're going to make me post it, I'm just going to say, and I've got a sort of a particularly egregious example from Citibank, where they posted a salary range of 0 to 2 million. Not sure if that was a mistake or not, but that was sort of going around on social media and on the internet as an example of businesses trying to get around the law. Now, to me, if it's something like that that's fairly obvious, you'd have a hard time as a business saying that was a good faith estimation of what the job would pay. But these pay transparency laws are a pretty big deal. 7 out of 10 workers say that they're likely to demand the top of the salary range, which makes a lot of sense from a worker's perspective. So it definitely adds to the wage pressure. It involves a lot more strategy when you're posting those positions. Some of you probably do these pay range things anyway. but some of my clients, don't list them and don't do that until the interview process. So something to keep in mind moving forward. And I've had some clients, post jobs that and Richard says he'll take the 2 million. I'm with you there, Richard. I would take the 2 million as well. So, some of my clients have asked about, well, what if we're not trying to hire somebody in New York, but what if our advertisements have been seen by somebody in New York? We get an application for New York, not even really consider the person because we want somebody closer in, but what's to prevent somebody from New York going to our website and filling something out. And I actually have had this issue come up, and I don't think it's quite clear yet what might happen in that, but there are sort of advocacy groups out there that are trying to call out companies that aren't complying with this, even if you're not specifically targeting somebody in the New York City area or another area where this takes place. So just keep that in mind. All right, in 2022, one of the big employment buzzwords was quiet quitting. I'm sure everybody's read an article about quiet quitting, but it was sort of a new phenomenon in the labor economy where you had employees. And I'm sure, even though the term quiet quitting wasn't around, everybody in HR has had experience with these type of workers. And it's employees that put in the bare minimum effort to keep their job and nothing more. And the idea is that they're sort of, collecting their paycheck while they are, looking for the next best thing because there's so many sort of opportunities out there. And so, it's a little bit unclear whether that's going to, continue. I mean, there were a lot of statistics thrown out about how often that was happening in the last year. Is that going to last into 2023? I'm not really sure. I think it probably depends a lot on the shape of the labor market and whether we're going to go into a recession or something like that. But that's something to keep an eye on as well. What can you do about it? Well, it's all the traditional, it's everything in the traditional HR toolbox, as far as performance evaluations, monitoring employee performance and things like that, to allow somebody not to just, sit on the payroll and collect a paycheck. One of those hot topics that you hear people talk about, I actually attended a CLE that had a little bit to do with this last night remotely, is artificial intelligence in the workplace. And I honestly think artificial intelligence in the workplace is probably its own webinar that, we may do something on later this year. But there's a lot of things happening in that space. Everybody's probably familiar with what's going on with chat, the chat bot. There was, for the first time ever, a client was represented in court by a quote unquote lawyer that was really just an artificial intelligence sort of chat bot. So they're coming for the lawyer. AI is coming for the lawyers as well. So it's going to be interesting to see what happens with that. The reason I thought about that was monitoring employee performance, and there's a lot of advocacy out there about whether artificial intelligence is going too far into privacy of employees with respect to monitoring their performance, whether artificial intelligence is inadvertently discriminating against employees and applicants. So that's something else I thought I'd mention that I think you're going to be hearing a lot about in legal and HR seminars this year. So one thing that we started to see in late in 2022, and as I've started to see it in the last month a lot, is that this idea of flexibility fatigue. COVID sort of ushered in this new era of remote work, and a lot of companies allowed, as an accommodation, or just because of the circumstances, maybe you were mandated by law or whatever the case may be, allowed a lot of workers to work remotely. Bringing those workers back to the office has been a big challenge for clients. I saw that we just passed in major cities in the U.S. the 50% threshold, which means that I think they looked at sort of commercial tenant occupancy numbers that we've reached 50% of pre-pandemic levels of people commuting back to work in the major cities in the United States. So people are coming back to the office. It's creating a big tension between management and workforce about that. Workers are, in some instances, rightly saying, well, I proved that during COVID that I can do my job from home. I know you say that it needs to be in the office, but I don't understand why. I've been doing it for 2 years at home. I've received good performance. Maybe I've been more productive, whatever the case may be. So there's been a lot of pushback on that. And businesses and HR that I talk to are just really tired of dealing with the, requests for remote work, whether that's in recruiting. I saw a statistic this morning when I was preparing for the presentation that, demand for remote work way outstrips the supply for remote work. So I think for every, there's two, people that want a remote work position out there for every one remote work job. And so, I've seen this in some boards and things that I've served on where we've had to search for, a new director or whatever the case may be. Everybody wants, either to work remotely or they want flexibility to be able to do so in some kind of hybrid work arrangement. I would obviously tell you to be careful of these sort of broad policies that say, all right, everybody's back to the office now, no ifs, ands, or buts, because I often see that employees are pretty wise now to claim a medical accommodation to have to work from home. And, those have to be and the Elon Musk Twitter example is sort of one of those broad-based policies that come back to work or you're fired type of thing. It's got to be a little bit more of a careful consideration if and when you do that. But yeah, there's usually nowadays, if employee says, hey, I don't want to come back to the office, company says, too bad, management's kind of evaluated this and made the decision that everybody's got to come back, like we're, workplace culture, whatever the reason is that's given. We got this nice, class A commercial office space. We need people in here that we're paying for. Then next step for a lot of employees is to, start calling up their healthcare provider friends to see if they can get a note. See that all the time, and there's no particular right way of dealing with that other than the same way you deal with any other accommodation requests under the ADA. So just keep an eye out for that. I came across a study recently. I think it was in one of the employment newsletters that I subscribe to. It was an article about the increase in freelancers in the economy. So independent contractors, 1099 workers, hiring those workers as opposed to W-2 employees. McKinsey Consulting, big US-based consulting firm, estimates that these sort of freelance workers make up 36% of the US workforce, up from 27% in 2016. So, I mean, I know that's a, near 7-year period, but that's a big number. Usually you see those numbers increase in sort of economic downturns. But the fact that it has sort of increased during a time of a strong labor market suggests that, it's probably a more permanent shift in business models. And certainly I think that freelancers or independent contractors are appropriate in many circumstances. I have recently advised clients, when they've had some type of unique situation with the worker that they may want to make that worker an independent contractor. But regardless, this is definitely an area where you need a really strong agreement in place. With W-2 workers in South Carolina with at-will employment, you can generally get by with something, like an offer letter or something like that. With an independent contractor, lawyers like to see a lot more detail, outlining what the roles and responsibilities are, what are the circumstances when you can terminate the agreement. And this is an area. Worker misclassification as independent contractors has been an area that's been on the Department of Labor's radar for quite a while. And I'll talk a little bit more about that here in 1 second. So a few agency related updates. We had a question yesterday submitted to us before today's presentation about the Federal Trade Commission's non-compete announcement. So for those of you who didn't see this, earlier this month, and there is a blog post on this, so another plug for the blog. Earlier this month, the Federal Trade Commission proposed a rule outlawing non-competes in the United States. So very, very drastic. California has done this, but in places like South Carolina, non-competes are very prevalent. And they, we could get into public policy debates about whether they're good or whether they're bad, but it's a big part of the labor economy in South Carolina and in many places. So this would be a really big deal. A few things about that. There's a 60-day public comment on that, which I believe has opened. I'll have to double check that. But after that 60-day public comment window closes, the Federal Trade Commission would vote on making that a final rule, which I think everyone expects, since it's the same people that proposed the rule, that will make that rule final. That they may make some adjustments based on public comment, but I think most experts think that that is going to become a final rule. Now, when it becomes a final rule, there will be, or we expect there to be, legal challenges to that. So, and essentially those legal challenges, and the U.S. Chamber of Commerce and business advocacy groups have already come out and said they're going to do it. And in those lawsuits, the groups would seek an injunction to prevent the rule from going into effect, which a lot of people think would happen. And the basis of those lawsuits is essentially that the Federal Trade Commission doesn't have authority to impose a nationwide ban on non-competes. If something like that were to be done, that would have to be done by Congress. Congress has not granted Federal Trade Commission the authority to do something like that. And so all that's to say that this is a very, very uncertain future at this point in time. I would not encourage any real drastic action at this point. But I would, pay very close attention to this story and monitor it. I mean, the rule itself is very broad in its application. It basically attempts to apply to every worker in the U.S. economy. And so, it would apply to entering into future agreements as well as ones that you've currently got with your current employees and rescinding those. And so, if this does start to look like it's a likelihood, there's going to have to be a lot of strategic business and legal planning that goes into recruitment, as well as how to approach, valuable employees that you may think you have locked down, but may soon be free to compete with you. The uh, the the Federal Fair Labor Standards Act overtime salary threshold, you see the current level there. This has been an issue for years now. The Obama administration tried to double the old salary threshold. The Trump administration approved a lower increase. So that's where it currently stands now. There was an announcement recently that the Department of Labor is eyeing May as another announcement of an increase in that. We don't know how big of an increase that's going to be, how likely it would be subject to challenge. But this is a priority for the Department of Labor and the administration. So that's something that we expect, sometime in late spring, and we'll keep you posted on that as that story develops. All right, I'll try to go quickly through some of these. So I mentioned the issue about how common it is now to hire independent contractors. The Department of Labor has a new test that applies only for the Fair Labor Standards Act, which is usually the law where the situation comes up the most. My colleague Katie Busby's got a good blog post on this, but essentially the new test, and this changes. It seems to change with every presidential administration, but the new test is the economic realities test, and it basically asks the question: is the worker economically dependent on the employer or in business for him or herself? And one of the primary focuses of that is the worker performing work integral to the employer's business. And so, is that a major sea change in how independent contractors are viewed? It's really tough to say how that's going to play out. But what I will tell you is that is definitely a test that favors the finding of a worker being an employee as opposed to an independent contractor. The government views classifying workers as independent contractors as cheating workers out of something. The IRS doesn't like it. They don't get their withholding. And so, this test is more designed to find that workers are employees rather than independent contractors. We got late in 2022, we got two laws at the federal level, the Pregnant Workers Fairness Act and the Pump Act. And it says up on the screen that the PWFA is similar to the South Carolina Lactation Support Act. That should really say that it's similar to the South Carolina Pregnancy Accommodation Act. The Pump Act is similar to the South Carolina Lactation Support Act. For South Carolina businesses, we already have these protections at the state level through those two laws that were passed a couple of years ago. So hopefully you're already up to speed in providing reasonable accommodations to employees with conditions related to pregnancy and childbirth. This PWFA is kind of modeled on the ADA, and it's the same idea that for pregnancy and childbirth, you've got to engage in an interactive process to determine whether or not requested reasonable accommodations need to be made. And like I said, this has already been a reality in South Carolina. And then the Pump Act is similar to the Lactation Support Act. The previously only hourly employees under the Fair Labor Standards Act were granted this reasonable time to express milk in dedicated space that's not the bathroom. So this is sort of an extension of that prior one. There is this protection in there for small businesses under 50 employees that you can prove an exemption from that law if you can show that doing this would be an undue hardship. Although I don't know that I could. It's hard for me to envision a scenario where I could advise a client that doing that was a hardship. But it is just something to note there. And then the final thing that I had on my list that might have escaped some attention was that the Speak Out Act, which passed on November 17th of last year, and that prohibited the use of non-disclosure and non-disparagement agreements concerning sexual harassment and assault. And the key thing with this law is that it only prohibits those before a dispute arises. So in other words, you'd be prohibited from having a blanket policy in your employee handbook, or entering into an employment agreement upon hire with a worker that had non-disclosure provisions in there concerning sexual harassment and assault. If an employee comes forward with an allegation and a quote unquote dispute arises concerning sexual harassment in the workplace, and that matter is settled through a settlement agreement, that those provisions can still be included within that, as long as the person's sort of resolving the dispute, and they're agreeing to at that time, knowing all the facts of the particular case. If they waive that right, once the dispute arises. So that was a very quick overview of some of the recent updates that we've had, as well as what to expect in 2023. I'll take a quick look here at the chat and in the Q&A to see if we have any questions. I don't see any right off. Richard's got a couple of good comments in there for people to take a look at concerning the OFCCP audit and the salary threshold for computer professional exemption. So I'm sure everybody's taking a look at those. We've got our next seminar. And by the way, feel free to email me or call me with questions. Always happy to answer those as well. You'll see up on the screen there our next webinar, Thursday, March 2nd at noon. And we've got our two immigration gurus, Garrett Steck and Caitlin Beck, who are gonna talk about immigration updates for you. So thanks everybody for coming out and attending today. I appreciate it. We had a great turnout. So we always appreciate the support from everybody, and hope everybody has a great day.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.